So you're about to have your deposition taken in a personal injury case. If you've never had your deposition taken before, I'm sure you're not happy about it. You're probably a little bit uptight, maybe a little bit nervous. The first thing I want to tell you is to relax and be yourself. Having a deposition taken in a personal injury case is important because when you think about it, it's the only time that the defense attorney is going to have a chance to meet you and to evaluate you. And so today, what I want to tell you is, and give you the benefit of my experience in participating in over 10,000 depositions over 40 years, and give you some rules on to how to maximize your deposition and give a winning deposition in a personal injury case. There are 4 areas I'm going to discuss: your appearance, the rules and how to give a good deposition procedurally, the content of the deposition, and then frequently asked questions. And my comments and my statements to you are dealing essentially with a deposition in a personal injury case involving an automobile accident. However, the same rules apply in a medical malpractice case, in a products liability case, in a boating accident case, in a construction accident case, in almost any type of personal injury case that you can think of. At this time, we'll focus on giving a good deposition in an automobile case. And remember, your deposition is the opportunity for you to answer questions yourself that are given to you by the defense attorney. I will be there as your attorney, and there will be a court reporter also taking down everything you have to say and taking down the questions that are asked by the defense attorney. I won't be asking you any questions. The questions strictly will be asked by the defense attorney, and my instructions to you on how to give a winning deposition really relate to the ability to give a deposition that is excellent, and so that you will improve the value of your case. Not necessarily win the case, but improve the value of your case as you are going through the deposition. Let me start with the initial instructions to you. Remember that when the defense attorney is taking your deposition, he's doing it to evaluate you. And he's evaluating you on the appearance that you make, your ability to discuss the facts of the accident, and the ability to discuss the impact of your injuries on your life. When the defense attorney finishes with your deposition, he'll report back to the insurance adjuster, and he will actually rate you. And he'll rate you in terms of what type of impression he thinks that you will make on a jury should your case be tried to a jury. The rating will be: the plaintiff makes an excellent, good, fair, or poor impression potentially on a jury. This is a very tough business, and it seems like you're being put on trial rather than having the defendant who caused the accident and caused your injuries being put on trial. But bear in mind that when the defense attorney rates you, he is reporting back to the insurance company, and the higher the rating that you get from the defense attorney, the higher the value of your case potentially for settlement. So what I'm telling you today is to give you pointers on how to get that excellent rating and improve or maximize the value of your case. When you appear for your deposition, and a lot of these comments are going to be common sense, you should dress essentially in neutral colors. You should be very clean, and you should appear well scrubbed, if you will. If you have facial hair, it should be well trimmed. If you have any type of markings or piercings that you'd like to conceal, please do that. And remember, as far as women are concerned, not to wear too much makeup or jewelry to the deposition, or any type of loud colored nail polish or things of this nature. In other words, your appearance should be as neutral as possible so that you don't give the defense attorney the opportunity to be critical of you or give you a lower rating in terms of what he thinks your impression will be on a jury. When you come to the deposition, as I mentioned, I will be there or an attorney will be there from our firm to sit with you and make sure that there's no badgering going on by the defense attorney and that the questions are fair. And then the defense attorney will be there. If it's more than one defendant, there'll be several defense attorneys. And then the court reporter will be there to take down everything the defense attorney and you are saying on the deposition. When you sit at the table for getting ready for your deposition, you should sit in an upright position, lean forward, and make eye contact with the defense attorney. You don't have to stare at the defense attorney, but make eye contact frequently, as this reinforces your credibility in the case. And credibility is everything. Credibility means believability, and that has to do with a jury believing in what you have to say compared to maybe other people in the case. The rules for giving a good deposition have to do with the way you express yourself and the way you respond to the questions that are asked by the defense attorney. Those rules basically are three to bear in mind. Rule number 1 is do not volunteer. Rule number 2 is do not guess or speculate. And rule number 3 is make sure you understand the question before you answer it. The defense attorney will be asking you a bunch of questions in the case. And remember that you want to focus in on each question as it's asked and not volunteer additional information beyond the question that is asked. The old phrase is, if somebody asks you what time it is, don't tell them how to make a watch. You want to strictly answer the question that's asked. For example, if the attorney asks you, do you know what day it is today? What's your answer going to be? The answer is yes. A lot of people would say, well, it's Monday, September 12th, or words to that effect. The question is a little bit of a tricky question, but I use it for an illustration because you have to listen carefully. Listen carefully to the questions in a deposition. It's not a normal conversation. Defense attorneys will like to try and act like your friend and buddy up to you in the deposition to try and get you to volunteer and be more conversational. This is not what you want to do. You have to bear in mind that the defense attorney is there asking you questions to get information that's hopefully beneficial to his case and beneficial to his client, the insurance company, in order to save that insurance company money. So make sure and not be in no doubt whatsoever that during the course of the deposition, this is strictly business and you should treat it that way. When I mention the primary rule to you, do not volunteer, that essentially means that if you can answer a question with a yes or a no and stop, answer it with a yes or a no and stop. If it's an open-ended question like, how did the accident happen? Then answer it with the proverbial 25 words or less. Just be short and to the point. Don't garble up your answer with additional information that the defense attorney is not really seeking in the question, because the more information that you give, the more questions the defense attorney will think of, and the longer the deposition will drag on. So just answer the question that's before you and listen very, very carefully so that you answer only the question that is being asked. Rule number 2 is you should not guess or speculate. If the attorney asks you a question and you don't know the answer to that question, the answer is, I don't know. If you're pretty sure about the answer but not positive, you can qualify your answer by saying, well, to the best of my recollection at this time, this is the answer. Or as best I can recall, this is the answer. Technically, all of your answers in the deposition are to the best of your recollection. So you could qualify every answer with that. But thinking about it, just be careful. Do not guess or speculate, because anytime you guess or speculate and you are wrong, that can come back to haunt you later on if the case is tried, and it would damage your credibility. The third rule for giving a good deposition is to make sure you understand the question before you answer it. That may sound like common sense, but you have to listen to the question and make sure you understand it. If you don't understand the question, feel free to interrupt the defense attorney and say, "I'm sorry, sir, I don't understand your question. Would you mind rephrasing it?" Attorneys, even experienced attorneys, will ask bad questions on occasion that are not really intelligible, and so you can stop and ask the attorney to rephrase it. And it's very, very important in giving a deposition to appreciate the fact that the court reporter cannot take down both people or two people talking at the same time. And so when you're answering the defense attorney's question, please remember to wait until the question is finished. I know sometimes people get nervous, they're uptight in a deposition. In a normal conversation, we anticipate what another person is asking us, and we respond with grunts or shakes of our head rather than verbally. This is normal and natural, but a deposition is not normal and natural conversation. You have to wait until the defense attorney is finished with the question, make sure you understand it, and then take a deep breath and answer the question. You can take as much time as you want to answer the question. And bear in mind that the last word in a sentence can change the whole meaning of the sentence. So if you attempt to anticipate what the question is before hearing the whole question and blurt out an answer, it may be either the wrong answer or an answer that may not be accurate and can come back to haunt you in the course of a trial if the deposition is used to impeach your credibility at the trial. There are some other rules that are important in giving a good deposition. One is to always tell the truth. The three rules I told you are the three main rules that you should go by, but you should always tell the truth, and that goes without saying. Even if the truth, a truthful answer you think may hurt you, it's by far better to do that and be truthful than to give a false answer that will come back to destroy your credibility later on. Bear in mind that the insurance defense attorney who is taking your deposition has access to a lot of information and will have had access to a lot of information before he arrives at the deposition. He will have your medical records. He will have your explanation of benefits from your insurance company. He will have past medical records that existed before the accident. So a deposition is not a time to attempt to conceal something or be inaccurate about your answer, because it is important for your credibility standpoint that you be accurate and truthful in every answer. Another thing to be aware of procedurally in answering questions in the deposition is that sometimes a defense attorney will ask you a series of questions that seem very simple and just require a yes answer. And then after 3 or 4 or 5 of those simple questions that you can answer with a yes, he'll slip in a damaging question in an effort to get you to answer another yes to it. Just be aware of that technique from the defense attorney, and be aware and listen carefully to the questions so that you don't get trapped by something like that. In addition, don't be afraid to stick up for yourself in the deposition. If the defense attorney asks you a hypothetical question and you don't agree with the hypothetical, you can modify it and say, well, that's not really what happened here the way you phrased it. This is really the way it happened, and this is the way I would answer that question. So you can parry the questions, and you can not have to agree with the hypotheticals that the defense attorney might ask you about the accident. Also, be aware of any effort by the defense attorney to have you make drawings or to make an X on a photograph of locations of things or what things look like. Anything you put down, and in most instances I will not allow, and our firm will not allow, any of our clients to draw diagrams. That's depending on the case, but be aware of any situation where you're asked to mark down anything or give a type of drawing or X on a photograph, because again, if it's not accurate, it can come back to haunt you, and we don't want that. Just a couple of other procedural points. We talked about the rules: do not volunteer, do not guess, and make sure you understand the question and always tell the truth. But there are certain other things as well. One is don't necessarily let a defense attorney put words in your mouth. As I mentioned earlier with regard to hypothetical questions, if the defense attorney is asking you a question and the premise of the question is not accurate, feel free to point that out and stick up for yourself. Be strong about your case, because you know the facts better than anyone sitting in the room. You were the one that was injured in the accident. Secondly, make sure that you don't ever argue or become contentious with the defense attorney. Most defense attorneys, in fact, in 99.9% of depositions, they're just there to get information. They're not there to trick you. They're not there to ask you questions that you can't answer. They're there to get information. And on the other hand, with respect to their getting information, they realize that the more information they get, the more likely it is that they'll have one or two pieces of information that may be favorable to them in their defense of the case. It's kind of like throwing out a net and fishing. If you get 10 fish, maybe you'll have 2 that you have to throw back. In this case, if you get, the defense attorney gets 10 pieces of information from you, maybe 2 will be favorable to him. If he only gets 5 pieces of information, maybe only 1 will be favorable to him. So you're there just to answer the question and not to volunteer information. And when you're doing that, never become contentious or get argumentative with a defense attorney. That can only hurt your case. Ultimately, you have to be calm and answer the questions in a calm way and in a matter-of-fact way and in a direct way in order to improve and bolster your credibility in the case. Now I want to talk a little bit about the content of the questions that you will get in a deposition in a personal injury case. You can look at the content of the questions and the actual questions themselves in a personal injury case as like a book with 3 chapters. Chapter 1, general background questions. Chapter 2, questions about the accident. Chapter 3, questions about your injuries. And most attorneys will proceed that way. They'll start out with general background questions to you. They will then go to questions about how the accident happened. They'll then go to questions about your injuries. They don't have to proceed in that order. They can start out with questions about your injuries and then talk about general background, then questions about the accident. They can do whatever they want, but by and large, they do proceed from the general background questions to questions about the accident to questions about your injuries. And the content of the deposition will vary depending on the facts of your accident. If you are in a rear-end collision caused by somebody else so that the fault is clear on the defendant, the defense attorney will probably spend a lot less time on questions about how the accident happened than he will on the general background questions and questions about your injuries. If liability is hotly contested, then he'll spend a lot more time talking about the accident. If the injuries are hotly contested, he'll focus more on that. But in general, the defense attorneys will proceed in the 3-chapter scenario that I gave you. General background questions first. Chapter 2, questions about the accident. Chapter 3, questions about your injuries. Now let's talk about the content of those questions. And we'll start with Chapter 1, general background questions. When the attorney starts in that area, and just like a book with the title, General Background Questions, there are subparts. Subpart 1, he'll ask you about your living history, where you have lived, for how long, the addresses, with whom you have lived, and why you have moved and where you have moved, and going back roughly about 10 years. Some people have moved a lot, some people haven't, but it would be good if you can remember the addresses that you have lived at and the people you've lived with going back over about 10 years. And all of these questions are permissible in a deposition, and they have nothing to do with the actual facts of the accident and your injuries, but in a deposition, the standard is questions that may lead to relevant material evidence. In a trial, the funnel is much smaller. It's just relevant material evidence. So most questions that you can ask at a deposition, you can't ask at trial, because the funnel at the deposition may lead to relevant material evidence is very broad and wide. So under general background, he'll ask you about subpart A, living history. Subpart B would be questions about your family history, past marriages, if any, children, what ex-husbands have done for a living, with respect to children, if they're old enough, what they do for a living, any divorces, where your divorce occurred, what county, what state, what jurisdiction, these type of questions with respect to family history. So I mentioned living history, family history. Third would be educational history. What's the highest level of education you have obtained? Have you gone to any professional schools or schools where you have received licenses? For example, training as a real estate salesman or broker, training as a surveyor, in addition to formal schooling in high school, college, or graduate school. They will ask you under the general background questions, subpart educational history, anything about your educational history, licenses you have obtained. You were a cosmetologist and you took the state test for that, a professional physician's assistant if you took the test for that, any type of educational licenses, certificates, diplomas, or degrees that you've obtained. So we've talked about living history, we've talked about family history, we've talked about educational history. Fourth would be work history. What jobs you have held over the course of the last 10 years, what were your duties and responsibilities in those positions, how much were you paid, why did you leave from one job to another, was it because you were terminated or was it because you moved because of a greater opportunity. They will want to know who your bosses were at the particular job. All of these things are under the category, subcategory of work history in the general background questions. So be prepared for that. If there's no claim for loss of wages, they probably won't spend too much time on that. But if there is a claim for loss of wages, they will spend a lot of time on that to look back at your work history to see what your earnings were, whether you made so much per hour or so much annually per year, whether you received any bonuses, worked 2 jobs, whatever your work history is. So we've talked about living history, we've talked about family history, we've talked about educational history, we've talked about work history, and finally they'll ask you questions about your medical history, which obviously in a personal injury case is most important. They will want to know over the last 10 to 15 years, every doctor you have seen, emergency room you've been in, hospital you might have had to stay in, for any reason, no matter how minor. And the reason that they are asking these questions is because they want to find out if you've had any prior complaints about the parts of your body that you are now claiming are injured in the accident in the pending case. This is obviously common sense. Insurance companies like to blame injuries on pre-existing conditions. So essentially that's what they're looking for. And they're looking for all of the names that you can remember of your doctors. And so the important thing here is, and we appreciate the fact that some people maybe not have seen many doctors in the last 10 years or so. Other people may have seen a lot of doctors because they have certain chronic conditions. It may be impossible for some people to remember every single doctor. But bear in mind that you should make every effort to remember the doctors that you have seen, particularly for significant conditions in the last 10 years, because to not mention a doctor and then the insurance company, which they will, find out through your own health insurance records what doctors you have seen, and you've left out one or you've left out two, you're claiming injuries to your neck or back, and you've seen an orthopedic surgeon 7 years ago with back complaints, but you didn't mention it, it looks very bad, even if it's an innocent mistake. So please make every effort to remember every doctor that you have been to, when you're asked that question in the deposition. Now, there are certain questions beyond the categories I just mentioned that they will ask you, and they ask everyone these same questions, so don't be offended when they ask you these questions. They're allowed to ask. These questions are not admissible at trial. And one of the questions is, have you ever been arrested? They will ask you that. If you've been arrested, if it's been more than once, tell them. That question is not admissible at a trial. They can't even ask the question at trial unless you conceal something. So if you've been arrested 3 times and you only tell them about 2, and they find out about the 3rd one, then they can bring it up to challenge your credibility at trial because you left it out. If you've been convicted of any crimes, you need to mention that, obviously. Anything from a DUI to shoplifting or anything like that, any convictions, any pleas of guilty, any pleas of what we call nolo contendere or no contest, if they're in your past, mention them. The truth will never hurt you. Concealment always will. Another question they always ask is, have you ever been treated for drug or alcohol abuse? Again, having nothing to do with the case particularly, but it's a question they always ask. They're entitled to ask it and answer it honestly. A third question they always ask is, have you ever been treated by a psychiatrist, psychologist, or social worker for any reason? And these are questions, again, that they're entitled to ask, particularly because in a personal injury case, you're making a claim for psychological damages when you say mental anguish or loss of the ability to enjoy life, which are 2 claims made, intangible claims, in a personal injury case. They are entitled to get any type of psychological or psychiatric records in the past. There are certain exceptions to that, but be honest if you have treated with someone, and they will ask you who it is and answer to the best of your ability who you have treated with and where and for what reason. Let's talk about Chapter 2, questions about the accident. And this is going to be strictly pertaining to an automobile type accident or a pedestrian auto accident, things of this nature. This also applies to almost any case, but there are certain other questions that might be applicable in a medical malpractice case or a slip and fall case or a product liability case. And we'll save those for another day. Strictly now we're talking about an automobile case and questions about that accident. So the defense attorney will ask you in an auto case, obviously, the date and time of the accident, and he will also ask you where you were coming from and where you were heading or going to just prior to the accident. Remember, the same rules apply procedurally as I mentioned earlier. Just answer the question that's before you. And the defense attorney will get to all the other parameters of the accident. So after asking you where you are coming from and where you're going to at the time of the accident, he will ask you, have you ever traveled that route before? What type of car were you driving? Was there anything mechanically wrong with your car? Did you have your seatbelt on just prior to the accident? With respect to your vehicle, was there anybody else present in your car at the time of the accident? What street were you traveling on? What direction on that street were you traveling on? How many lanes in one direction and the opposite direction were on the street that you were traveling on? Which lane were you in at the time of the accident? With respect to the questions about liability, bear in mind that there are two areas that you need to be very wary of, and I call these time and distance questions. For example, let's take an intersection collision where you're traveling, let's say east on Palm Beach Lakes Boulevard in Congress, and someone heading north on Congress runs a red light and T-bones you or hits your vehicle in the side. Let's use that as an example. Besides telling the defense attorney in response to his question what direction you were heading in, what lane you were in at the time of the accident, he'll ask you what the weather was like. Was it clear and dry? Was it rainy with a wet road? And you will mention, he'll ask you what part of the defendant's car or vehicle hit or impacted what part of your vehicle. And if it was a T-bone collision, you would answer accordingly. Hit my passenger side, middle of the car at the time of the accident. So the middle of my car on the right or passenger side impacted with the front of his car in the course of the accident. But the time and distance questions are important because he might ask you, did you notice the defendant's car before the impact? If you say yes, he might ask, well, how far away from it was you when you first noticed it? That's a distance question. The time question might be, how long before the impact did you notice the defendant's car? And that's a time question. The important thing to remember here is that when somebody's involved in a traumatic incident like an automobile accident, time and distance get very distorted. Some people say it's like going through slow motion before the traumatic event occurred. So, for example, if he asks you how long before impact did you notice the defendant's vehicle or car, and you say 5 seconds, as opposed to the microsecond or half second it may have been when you first noticed it, that might allow the defense attorney to argue that, well, 5 seconds, you're traveling at such and such a speed, had you braked or had you accelerated, you could have avoided the accident. So just be wary of these time and distance questions, and if you're not sure, just say, I don't know. Or if it did happen in an instant, say, look, I noticed the car briefly. It was an instant. I didn't have time to brake. I didn't have time to take any evasive action. Same with the distance. Sometimes if you say you noticed the vehicle before impact, they might ask you, well, how many car lengths was it away from you at the time? Again, don't guess or speculate about this. If you're not sure of the distance, just say, I'm not sure. I can't tell you how far away it was. All I know is I didn't have time to take evasive action or to hit my brake. So the time and distance questions are something to be aware of. Defense attorneys make a living by getting plaintiffs committed to times and distances that are going to hurt them in terms of their ability to take evasive action or brake before impact. The defense attorney will continue on with, besides asking you what lane you were in, he'll ask you how fast you were going. Again, be careful about the speed question. Always be aware of what the speed limit is and the particular stretch of roadway you were on, and be aware and make yourself aware as best you can think back to roughly how fast you were going, so you can give an answer. If you have to give a range, like I was going 40 to 45 and the speed limit was 45, that's fine. But any estimate of speed, obviously over the speed limit, is going to cause the defense attorney to argue that you were negligent as well for speeding. Now, with respect to questions about your car and any mechanical defect, if it was raining, he might ask you if you had your lights on, were your lights working. If you were stopped at a red light at the time of rear-end collision, he might ask you if your brake lights were on. He might ask you if your turn signals were working, or did you have your turn signal on when you were going to make a turn just prior to the accident, and questions of this nature. Just be careful about answering those questions and make sure that you're accurate, because there will be potentially witnesses that are there that can either corroborate or disagree with any testimony that you may give. Now, when the defense attorney asks you about the accident and all the issues and factual questions that I just mentioned, he will then potentially ask you to grade the impact. Was it a light impact? Was it a medium impact? Was it a heavy impact? At the time of the impact, they always ask this question: what part of your body made contact with what part of the interior of your car when the impact occurred? Maybe because of seatbelt, maybe none of your body made impact with any parts of the car, but in many instances, depending on the location of the impact, your body might be thrown sideways, make contact with your door. Your body may have been violently moved forward to the extent that you made contact with your chest with the steering wheel, or your knee with your dashboard, or your foot with something. You just have to remember as best you can at the time of impact what impacts occurred with your body inside the vehicle. Once he asks you that question, then he will want to know how long did you stay in your car before getting out of it, or were you able to get out of your car at all, or did you have to be assisted of getting out of your car by maybe EMTs that showed up. Nowadays, they will always ask you just prior to the accident, were you using any type of cell phone or device? Did you have your cell phone in the vehicle? Was your radio playing? Were you looking down to change channels with your radio? They will always ask you what your cell number is and your cell phone provider, so that they can subpoena your cell phone records to see if you were making any calls or texting at the time just before the accident. And the defendant is asked those same questions too. But that's very important nowadays because of people using cell phones while they're driving, and this is now prohibited. And to the extent that you may have been on the cell phone, even if the accident wasn't your fault, that can be used against you at the time of trial if the case is tried. Once he asks you those questions, and particularly if it's raining, he might ask you if your windshield wipers were working at the time. Was there any blockage to your visibility? Could you see everything ahead of you? Were you going uphill or downhill? What was the traffic like that day? Was it light, medium, or heavy? All of these questions will be asked in the Chapter 2 questions about the liability. Once the accident occurred, the defense attorney will ask you where your car ended up. Did it move forward? Did it impact another vehicle? For example, in a rear-end collision, If you're hit hard enough and there's a car ahead of you, did your car move forward hard enough or far enough to impact the vehicle in front of you? If it's a T-bone collision, as we were discussing earlier, did your car spin, go to the other side of the road, change direction? Where did your car end up? Now, once the accident happens, the defense attorney will ask you, did you get out of your vehicle? How long were you at the scene prior to leaving? If you're so severely injured in the accident that you require medical assistance, he will ask, if the EMTs took you out of your car, emergency medical technicians, if they put you in an ambulance, what hospital did you go to? Did you refuse medical care after the accident? Why did you refuse medical care after the accident? When you got out of your car, what did you observe? Did you observe the defendant driver? What did you observe about the defendant driver? Did the defendant driver appear to be under the influence of anything? Did you overhear anything the defendant driver said at the accident scene? Were there any witnesses that came up to you and talked to you after the accident? Do you have names of any witnesses that were present that witnessed the accident that gave you their information? All of these things will be asked of you about your activities at the accident scene. And you will also be asked, of course, did you experience any pain at the accident scene? This type of question can have a variable answer. A lot of people, even if they are severely jostled around inside their vehicle at the time of the accident, because their adrenaline is pumping, although they might feel some slight pain in their neck or back or their knee or their foot or their ankle or their arms or wrists, they might not notice it as much because the adrenaline would tend to mask it, which is a normal reaction from being in an accident. A lot of times people will say, well, I didn't feel that much pain at the scene. The pain I did feel I thought would go away. Therefore, I didn't need really to be taken to a hospital. So I turned down the EMT's offer to take me to the hospital. I drove myself home if my car was drivable, or if not, I called my wife or brother or somebody picked me up at the accident scene, or the tow truck driver took me back, who carted my car off the scene. You'll be asked how much in property damage your vehicle sustained. If you know, what was the estimate for property damage? Has your vehicle been fixed? Do you have any photographs? Very important to take photographs, if you can, at the scene and of the damage to your car and the damage to the other vehicle, if possible. Obviously, if you're hurting and you're put in an ambulance, you're not going to be able to do that. But if you're at the scene and it's possible to do that, that's important. A lot of people will say if they didn't feel a lot of pain at the scene, they thought the pain they did feel will go away, and they go home and they lay down, and 3 or 4 hours later or the next morning they can't get out of bed because they're stiff and they have a lot of pain. That's a common type occurrence. But you just have to answer what relates to your particular scenario. And now we're going to discuss, if you will, Chapter 3 of your deposition type questions about your injuries. And there's always a transition point from the defendant asking you what hurt at the scene, if anything, what pain you had at the scene of the accident, if anything, to the point where you sought your first medical advice and your injuries started to be documented. Now, obviously, if you're taken by ambulance to a hospital, that's going to be self-explanatory, and there will be records of the EMTs, emergency medical technicians who run the ambulance, make their own notes. And so when you tell them that something hurts, and classically, if it's a neck or back problem, they'll put you on a backboard and put you in the ambulance before taking you on to the hospital. They may give you an IV while you're in the ambulance, but all of this will be documented in their notes. And anything you told them about what is hurting, or if you've lost consciousness, for example, which is very important to document, should be documented in the EMT notes as they take you on your way to the hospital. And once you get to the emergency room, there'll be further documentation by the nurses and doctors there of what your complaints are. And obviously, if the complaints are severe enough to be admitted, then there'll be further documentation for your stay in the hospital after the accident. If you decline medical treatment at the scene from the EMTs or decline their offer to take you to the hospital, which is not uncommon, and you go home or someone takes you home, then they will want to know when you first sought medical advice and with whom you sought medical advice. And if you sought medical advice initially with your, whether it's your primary care physician or a chiropractor or an orthopedic surgeon or a neurosurgeon, the defense attorney will always ask you how you got to that particular doctor, who recommended that doctor, how did you know about Dr. So-and-so. And to the extent that anyone in this firm may have recommended a physician, we usually recommend multiple physicians, so you make the choice. And a lot of it depends on where you live. If you live in Lake Worth, we might recommend someone in your area. Obviously, we're not going to recommend somebody up in Palm Beach Gardens or Stewart. So, but the point here that I want to be clear about is that you should never testify as to any conversations between anyone from this law firm and yourself. That is protected by attorney-client privilege. And so if any question is asked, for example, if someone in our firm recommended a particular chiropractor that you go to, and we are aware of that, obviously, we will object and instruct you not to answer with any communications that were made between our firm and yourself, as they are protected by the attorney-client privilege. If your own physician or primary care physician recommended an orthopedic surgeon or a chiropractor, that's fine to mention that. If a friend recommended a chiropractor, orthopedic surgeon, or a pain management person, that's fine to mention that. You just can't testify as to any attorney-client protected communications between our firm and yourself. Once the defense attorney finds out in the deposition what doctor you first sought care from, then he will start asking you about your injuries. What injuries do you feel that you sustained as a result of the accident in question in this case? And different attorneys do it different ways. That's one way a question could be asked. Another way the question can be asked, and I've seen this done by defense attorneys, is from the tip of your head to the bottom of your feet, what parts of your body do you feel were injured in this accident? And they will want to know specifically if it's a shoulder, if it's a knee, if it's a low back, if it's a neck. They will want to know specifically what body parts were injured. Obviously, if you've had surgery, that's going to speak for itself. But to the extent that you suffered torn ligaments or a soft tissue injury that didn't require surgery, then the explanation of where the injury occurred is very important, and what symptoms that you had. Did you have swelling? Did you have pain? They'll want to know where the pain was located and what type of pain it was. Was it sharp? Was it dull? Was it throbbing? Was it intermittent? Was it constant? How frequently did you have pain? And on a scale of 0 to 10, with 10 being the worst, what type of pain were you experiencing as far as severity is concerned? If there's a loss of wage claim, the defense attorney will want to know, has any doctor told you that you can't work as a result of the injuries that you sustained in this accident? Or have you been put on any restrictions as a result of the injuries that you sustained in this accident? If you're working a construction job and you're lifting, 50 pounds or more frequently throughout the day, and your doctor tells you you shouldn't be lifting any more than 5 or 10 pounds because of your back, that's going to be important to explain that in terms of if you have a lost wage claim, why you can't do your job, because you're restricted in terms of your lifting ability. If a doctor tells you are to avoid kneeling and squatting, turning, some type of body movements that are required by your employment. For example, if you're a waitress and you've got to carry trays and you've got a wrist injury and you've got to carry the tray like this, but you can't do it because of the wrist injury, this is important to document, and you will get questions about this. Obviously, for more severe injuries where there are paralysis or missing limbs or things of this nature are going to be pretty much self-explanatory. Vision problems, memory problems with a closed head injury. If you're a waitress, we've had cases where a waitress can't go up and ask for an order because she can't really write down the whole thing, remember even to write down the whole thing, and it becomes an issue preventing that person from doing the job. If you've got a problem with your eye and you are working at a computer and you're working with numbers and you can't see, or you've got extreme headaches because your vision will not clear, that is something obviously that could interfere with your desk job. If you've got a low back problem and you can't sit for long periods of time and your work requires that, that could interfere with your job. It's just very important to document these things with your physician, and it's important to, in answer to the defense attorney's questions in the deposition, to be as accurate as you can with the complaints that you have and the treatment that you've received. One thing that's defense attorneys like to make a living on, again, is if there's what's called a gap in treatment. So if you've gone to and gotten conservative care for a spinal complaint, let's say with a chiropractor, and then have had an MRI documenting herniated discs, for example, in your neck, and then have gone to an orthopedic surgeon, and the orthopedic surgeon has told you that you need to get injections or you may need to have surgery, more invasive treatment, as opposed to a brace and medication, chiropractic adjustment or physical therapy, and you have not proceeded to get that recommended treatment, and there has been a gap in treatment of 3 or 4 months or more, then it allows the defense attorney to argue that, well, your complaints of pain can't be that severe because you haven't gone back to the doctor, you haven't gotten the physical therapy, you haven't gotten injections in your spine, you haven't gotten the surgery, and so all this is something to keep in mind when you are being asked these questions and when you are treating for your injuries. The other important thing is to make sure when you're asked about your injuries that your testimony is consistent with what's in the medical record. In most cases, we will do a chronology. We'll make sure you have copies of your medical records, and it's important to see what the doctors wrote down about your treatment, and so that your testimony is consistent with what the doctors are saying. Or if there's a discrepancy in the medical record, that's important to know as well. So it's just very important that you be accurate in depicting your injuries, and that you are accurate in telling the defense attorney what the consequences of those injuries are, as far as pain, as far as restriction in range of movement, and what parts of your body do you have that, and whether or not, for example, you've had surgery recommended. If surgery, for example, has been recommended, whether it's a knee or the spine or the shoulder or what have you, and you haven't received the surgery yet because you're deciding as to whether or not to get the surgery, it's important in a deposition to say that you will definitely consider getting the surgery in the future. If you say, no, I'm not going to get the surgery, then a claim can't be made for it. If you say that I'm going to consider getting the surgery in the future, and nobody has a crystal ball as to whether or not you'll get the surgery or not, that's important because that allows us to claim the cost of what that potential surgery is. If you say, I'm not going to get the surgery and we can't make a claim for it, and the case is settled on a lower level, and then a year after your case is settled, you're hurting so bad you get the surgery, you're not going to have the money for it. So it's always important to leave the door open on getting future treatment, whether it be injections, whether it be surgery, or some other type of treatment that's been recommended to you. Defense attorney might ask you, have you suffered any injuries to the parts of the body that you're claiming injury from this accident in prior to this accident? Have you ever had any previous chiropractic treatment? Have you ever had any previous treatment by an orthopedic surgeon? Have you ever previously had to have an MRI of your neck or low back or knee or shoulder? They will ask you about any prior treatment in terms of medication you've taken. Have you ever complained to any doctor about pain in the low back? Have you ever complained to any doctor about pain in the neck or pain in your knee or pain in your shoulder? Once again, if you've had problems in the past, please disclose them, because the defense attorney will probably know even before the deposition the answer to those questions, and certainly will find out at some point by getting your prior medical records, by getting your prior hospital records, by getting your prior chiropractic records, by getting information from your insurance company. They're called explanation of benefits, EOBs. Insurance companies keep lists of all these things. And I can tell you I've had situations where a client, for example, told me they had been to 9 physicians in the past when it was almost 90 physicians in the past. And there's nothing like walking into a deposition and seeing the defense attorney holding a list of EOBs that is 5 pages long with print this big, each a bill submitted by a prior physician, and then having to sit through 4 or 5 hours of testimony about why this physician wasn't disclosed or why that physician wasn't disclosed. Some people have had problems with arthritis and may have gone to a rheumatologist or even a primary care physician and said, my back is aching a little bit, and particularly if you're working a physical job. If you're working construction or you're cleaning pools or something, and you have a little ache and pain here and there, that's normal and that's to be expected. So don't conceal any of those things. There's a big difference between those kinds of intermittent complaints and neurological complaints like I have no feeling in my arm or in my leg because of a nerve root compression caused by an accident. Those are significantly different than ordinary maybe back spasm or something like that. So if there's been anything in the past, please make sure it's disclosed. The defense attorneys also would like to ask if you know what your total medical expenses are. Well, it's not necessary to know the answer to that question, but they also like to ask the corollary question, well, how are your doctors getting paid? Have you paid anything out of pocket to pay your physician? Do you know whether your physician is operating under what's called a letter of protection, or LOP, from your law firm? What this means is that sometimes, and we don't do it as a matter of course, only rarely will we issue a letter of protection whereby we tell the doctor that we will pay the doctor's bill out of any potential recovery. It's really not necessary to do this because we would do that anyway, but in a lot of cases, if the doctor accepts, for example, Medicare or Medicaid, they can't balance bills, so there will be no balance for the doctor. If the doctor is a provider under your health insurance contract and accepts those benefits for the treatment he's giving you, he can't balance bill. So there will be no additional bill. The doctor's bill might be $10,000. He might get $2,000 from the health insurance carrier, and he's got to write off the difference. So it's rare that we give a letter of protection, but defense attorneys like to ask these questions because they want to make it seem like the doctor has a vested interest, has got skin in the game in the personal injury lawsuit that you've got, and that's why he's incentivized to testify that your injuries are very severe because otherwise he might not get paid. That's the theory behind the defense argument. And it really doesn't hold water, particularly because the doctor, and obviously most doctors are totally ethical and they're going to give you the treatment that they think you need medically, irrespective of the billing aspect of it. But secondly, in many cases, they've gotten paid through either your personal injury protection, or they've gotten paid through your health insurer, or through Medicare or Medicaid, and so there's no incentive whatsoever for them. But the defense attorneys like to ask these questions in any event. Another thing that they like to ask is, are you feeling better today than you have in the past? Do you feel that the medical treatment that you've gotten has been effective? And what they're trying to do there is they're trying to show that you're feeling a lot better now, and you really don't need as much help from the jury for paying for future medical expenses and so forth as the jury might be asked to do. So obviously answer that question as accurately as you can. If you've been bedridden and you've had problems walking and so forth in the past, and you've needed a cane, or you've needed a walker, and now because of the medical treatment you're walking without any assistance, of course you're going to be better. So just be careful and explain that, but be detailed in the way you respond to that in terms of what the problems are that you're having today. And I'll get to that in a minute. But defense attorneys also like to ask, well, has any doctor told you that you have a permanent injury within a reasonable degree of medical probability? The doctor might have not discussed that with you, but there's a concept called maximum medical improvement, MMI, and defense attorneys are aware of this. And what that means is you suffer an injury as a result of an accident, and your injury might keep you down or might have a tremendous impact on you for a period of 2, 3, 4, 5 months. And over time, you reach a plateau. From the medical treatment, you improve, and you get to a certain point, and your medical condition plateaus out. So, for example, if you've never had back problems before an accident, and now you have a severe low back problem with a herniated disc, you may have had that difficulty walking right after the accident, but the treatment that you've gotten, whether it be physical therapy, chiropractic adjustment, medication, muscle relaxers from an orthopedic surgeon, and bracing, ultimately maybe injections, and now you're up here, you're able to walk, you're no longer in the wheelchair, you're no longer using a cane or a walker. Of course you're going to be better, but now you still have the intermittent pain. It doesn't cause you to have the walk with a device or assistance or anything like that, but that is the difference. And so if you have a herniated disc, the doctor may have told you that, but he may not have mentioned whether it's going to be permanent or not. But you might be asked that question, whether any doctor has told you you have a permanent injury. And if you know the doctor has told you, tell him. If you don't know, you can say, I don't know. They might ask you if you feel your condition is permanent. You can say, well, after 6 months or 9 months or a year or however long it's been, if you still have these problems and you didn't have these problems before the accident, that's the way you should explain it. With respect to your medical treatment, they will ask you if you have any appointments scheduled in the future with any physicians. That's important to document. If you have appointments for the future with physical therapists or chiropractors or the orthopedic surgeon or neurosurgeon or pain management, it's important to discuss that. They may ask you, has your pain been bad enough after this accident to have to resort to taking any pain medication? Obviously some people don't like to take medication and would have to be an extremist to do it. Some people will just do over-the-counter medication. Other people, the pain is so bad they may take narcotic pain medication. It just depends on your given situation. So if you've taken, for example, narcotic pain medication because the pain was severe in the beginning, but now don't want to do that and you're taking over-the-counter medication, just describe whatever your situation is. If you are taking medication at the time of the deposition that's been prescribed by a doctor for your injuries, and the defense attorney asks you that question, you'll need to answer that accurately. They may ask you if any of the medication you're taking impairs your ability to answer questions in the deposition. Obviously, most do not. And they may ask you if some of the pain medication you're taking or any type of medication you're taking as a result of the injuries you sustained in the accident have had any side effects on you. And to the extent that they have, you can outline that. If you were on medication at the time of the accident, back in the Chapter 2 on the liability and how the accident happened, they may ask you whether you're suffering any side effects of medication you were taking at the time of the accident, at or before the accident occurred. So answer the questions accurately in terms of your medical care and treatment, what your injuries are, and your medication. They'll also ask you when you have, if doctors have prescribed medication for you as a result of the accident you sustained, what pharmacies you go to fill those prescriptions. And they always subpoena the pharmacies to see whether you've gone and filled the prescriptions and what you've gotten and what type of medication that you've obtained. They always ask too, as kind of a side note, in the past, since this accident occurred, have you taken any vacations? Have you traveled anywhere? They want to know if you're sitting in a car for bunches of hours, if you're driving the car, if you've had to sit in a plane for a bunch of hours, if you've gone to different places, Las Vegas, Mexico, wherever it is, vacation. Are you out there dancing around and jumping around, diving in pools, and this type of thing? They want to know if any photographs were taken at or video of vacations and who has custody of those, so they can get those. So be wary of those questions. They may ask you, since the accident occurred, have you participated in any type of social activities in terms of birthdays or anniversaries and so forth, and have any photographs or video been taken of those? So just answer those questions as accurately as you can. With respect to your injuries, ultimately they will ask you today, at the time of the deposition, what is bothering you now? Where are you having pain now? What is the nature of the pain again? How severe is the pain? How frequent is the pain? How does it interfere with your activities of daily living? And it's very important to give them examples of that. One of the questions they always ask is, are there any activities that you cannot do now as a result of the injuries that you have sustained in this accident? That should be probably a very short list, unless it's a traumatic, very traumatic injury. Remember, they're asking you, are there any activities that you cannot do now as a result of the accident? And the corollary question they will ask you is, are there any activities that you do now but with difficulty or with pain or more slowly as a result of the injuries that you sustained in this accident? And always answer these questions with specific examples. For example, I used to garden. That was my hobby before the accident. Now I can't kneel down, I can't bend down because of problems with my knee or problems with my back or shoulder. That's just one example that you could give. Used to like to play tennis before the accident. Can't do it now because I can't run around or I can't serve because of the issues with my neck, back, shoulder, or legs. It's something that is a common sense type thing, but bear in mind that the distinction between activities you cannot do at all and wouldn't even attempt to do as a result of the injuries you sustained in the accident, and activities that you may be slowed down in doing or do because of pain more slowly or are limited in doing because of the injuries you sustained in the accident. Now, also be aware of the fact that there's been a great tendency of insurance companies to do video surveillance of plaintiffs now. Video surveillance is basically the insurance company hiring someone from Equifax or some investigative company that gets paid by the hour to come out, and the way they do it is they come out to the location where you live. They'll have your address, they'll probably have a picture of you, and they'll have a section of the report that says what your claimed injuries are. And they'll come out with a car in your neighborhood. They'll park 600 or 800 feet away because they'll have a video camera with a telephoto lens on it. The windows of the vehicle that they're in will be blacked out so you can't see them. The video camera will either be on a tripod in a van, or they'll hold it manually and brace up against the seat when they do the video. Bear in mind, they can't take any video inside your home. That would be an invasion of privacy. But once you come out through that front door, through that threshold, and come out into the general public area, it's fair game. And the reason they park down the street is they don't want you to see them. They will zoom in on your front door early in the morning, hoping to catch you coming out of your house, going to work, going to the supermarket, going to the gas station, going to the park, or wherever you're going. They will follow you. And they'll attempt to get video of you doing activities that are inconsistent with your testimony. And a lot of times I can tell when they've done the video surveillance before the deposition, because the video surveillance in 99% of the cases is worthless. It's only worthwhile if you deny doing some activity that they have you on video doing. And in order to make the video useful, a skilled and experienced defense attorney is going to have to ask the exact question. In the past 6 months, for example, did you climb a ladder onto your roof to get the leaves out of your gutter? Okay, because they know they've got that on video. That's a very specific activity, and when they ask the question like that, you know that they've done the video surveillance. So what the clear response to that is, if you did it, admit it. Okay, acknowledge the activity, whatever it is, even if it seems extremely hurtful, because it makes the video that they have useless. Again, you're telling the truth, you're responding truthfully, and the video will never even know it was taken, because they don't even have to disclose it unless they plan to use it right before the trial. So just be very wary of that, because that is important in terms of being truthful and accurate in your deposition. Every physical injury usually has a psychological or an emotional component to it. So for example, if a man is the sole breadwinner in his family and he suffers an injury in an accident through no fault of his own, and he can't work anymore to earn that kind of money, and his family is suffering because of his inability to work, it creates a source of some severe potential depression and psychological component injury, as well as a physical injury. And so defense attorneys will ask in a deposition sometimes if you have sought psychological or psychiatric assistance as a result of the injury suffered in the case, and if you have, you can talk about it. If you have suffered that injury or feel that your injury has impacted you emotionally, and you're asked that question, you should discuss that and how it's made you feel. If it's impacted your relationship with your wife or your children, you should talk about that. If you're asked the question, do not volunteer, but if you're asked the question, you should answer that question accurately and truthfully, and how it's impacted your relationship with your wife or family. It can have obviously a physical impact on your intimacy with your wife if you have severe injury. It can have an emotional impact if you get short-tempered, you're not as patient as you used to be, and you snap back at people, whether it's your spouse or your children. That can have a very deleterious effect on those relationships. And so the physical injury, the impact of the accident on your life is not just the physical injury that you've suffered, but like throwing a pebble into a lake, it spreads out in the circle, affecting the people that are closest to you, your children, your spouse, your friends. You may not want to socialize as much. If you have a hearing injury, if you have difficulty maybe speaking or keeping up because of a closed head injury in conversations with friends, or you just can't stand a long time, so you don't want to go out and to a cocktail party or a charity that you've done in the past. All these things can have an effect on your life. And if you're asked those questions, it's important to respond accurately and truthfully to them. There are certain questions that are always asked by our clients about their depositions. Number one is, how long is it going to take? And obviously that depends on the particular situation, whether it's liability or damages. But the average deposition in a personal injury plaintiff's case involving an automobile accident probably should range from 1 to 1.5 hours with a skilled attorney. I've seen them as short as 40 or 45 minutes, and I've seen them go on for hours and hours because there's been too much volunteering, or the attorney isn't experienced and just keeps asking questions that are really not relevant or material and not going to have any bearing on the case. But on average, from an hour to an hour and a half. With respect to the time, obviously, if there's more volunteering than there should be, that will lengthen the deposition considerably. And so that's why we talk about that and urge you that you should not, rule number one, not volunteer. Social media. It's very important to mention that in preparation for your deposition. Almost everyone now has Facebook or Instagram or tweets on Twitter. And so it's very, very important that you not disclose anything about your accident or injuries on any social media platform. Insurance defense attorneys now found a new area that they can dig into. They can have people search the social media themselves, or they can subpoena the social media companies and subpoena you to produce documents from your social media accounts, so they can, again, go on a fishing expedition and hope to find something that's beneficial to them and detrimental to your case. If you have a serious back problem, for example, and you're posting video on social media, if you're jumping on a trampoline or tumbling in a gym, that type of thing is certainly not going to be helpful to you. Another question I'd like to ask is, have you, besides the vacation question I mentioned earlier, do you have any memberships in any gyms, or do you work out on a regular basis? A lot of people have memberships to different types of workouts, Orange Theory, CrossFit, Bally's, whatever, Gold's Gym, and Schuler Shooting. If you do have such a membership, they'll be subpoenaing those records to see what you've done there, and in terms of your physical activity, to see if there's anything they can find that's contrary to what you're representing you can and cannot do. So these things are very important. And finally, the last thing I want to mention is that probably the best thing to review in terms of preparation for your deposition are your answers to interrogatories. These are the written questions that we sent to you earlier on in the litigation that you've had to provide written answers for. The interrogatory questions are basically the same questions you're going to be getting. When I say interrogatory, the written questions are basically the same questions you're going to be getting verbally in the deposition, only in more detail. So reviewing your answers to those written questions is very important to refresh your recollection and to make sure that you were thorough and complete back when you answered those, and to be consistent in your verbal answers in your deposition. So that is the final note I'll leave you with in terms of preparing for your deposition. We want to make sure that you give the best possible appearance and the best possible answers you can give in your deposition to maximize the value of your case, and so that we can get the best possible value to compensate you adequately for the injuries that you have suffered at the hands of someone else's negligence. Thank you.